kind of how do you say, so good evening, everyone, and welcome to Inside the Room, Attorney-Diplomats at Work on U.S. Foreign Relations, Part 2, organized by the Washington Foreign Law Society. This is the second of the two events. If you missed Part 1, please go to our website under Past Events, and you will find the recording of February 17 event. I'm Juliana Canet, the president of the Washington Foreign Law Society, founded in 1952 to promote knowledge and understanding of international legal matters, comparative legal issue, and foreign law. Given the number of participants, you will be muted during the webinar, but able to communicate with us via Q&A section. Please send questions for our distinguished panelists using Q&A section on your screen, and we'll get to your question toward the end of the presentation. The session will be recorded. Let me introduce our speaker. Two distinguished attorneys with decades of accomplishment in foreign relationship and national security affairs in government and in private practice. Tonight, Mr. Feldman will interview Mr. Smith. You have their full bios in the invitation. They're worth reading. Briefly, Mr. Smith has an exceptional career as the State Department lawyer, General Counsel of the Senate Armed Service Committee, General Counsel of the CIA, and a stalwart of our non-reported national security practice. Most recently, he represented Ambassador William Taylor in the first Trump impeachment trial. Mr. Feldman has practiced law for 60 years, including 16 at the State Department, where he was deputy and often acting legal advisor. He teaches foreign relations law at Georgetown and is well known as one of the drafters of the Foreign Sovereign Immunity Act. One final note before I hand the floor to our panelists. Please consider becoming a member of the Society. We have discounted rate for student and government employees. I will put a link on the chat. Welcome, gentlemen. The floor is yours.
Thank you very much, Juliana. I want to welcome everyone here and say what a great honor it is for me and for the Society to have Jeff Smith with us this evening. This is the second part of a two-part series. A month ago, Jeff was kind enough to interview me when I spoke about Vietnam, working with Henry Kissinger, and the Iran hostage crisis. Tonight, Jeffrey Smith is going to speak to us about three topics. He's going to talk about the bridges of spies, that is to say, the exchange of spies between the United States and the Soviet Union during his career that he was deeply involved in. He's going to talk about the trial of a man by the name of Kim Dae-jung, who was for many years the president of Korea and a Nobel Peace Prize winner. But Jeff knew him many years before that when he was on trial for his life in Korea, and Jeff was the U.S. observer at that trial. And then he's going to wind up the program tonight by leading a discussion of the Iran-Contra scandal in the early part of in the Reagan years. It's a personal pleasure for me to have Jeff here. I've known him for many years. I first met Jeff when he was a young lawyer at the Pentagon, working on Panama Canal issues, and I had the pleasure of recruiting him to the State Department. He presented himself with a little different resume than we usually get with the West Point. He was a West Point graduate, and he had Ranger training and I knew immediately that he would bring something to the striped pants universe of the State Department, as they used to jokingly call us. And I never had striped pants, I have to say. But Jeff, as Juliana, our wonderful hostess, has said, went on to an exceptional career, rising to be General Counsel of the Senate Armed Services Committee, General Counsel of the CIA, and a leading practitioner at Arnold and Porter. So we're going to get started with The Bridge of Spies. If any of you who have seen that film starring Tom Hanks know that, and I should say Mark Ryland, know that will recall the events of, I think it was 1952, right, Jeff? In the Eisenhower years, when Gary Powers flying a U-2 over Soviet skies, or at least at the edge of space over the Soviet Union, was shot down, and eventually an exchange was worked out with the good services of an American lawyer by the name of Donovan and an East German lawyer by the name of Vogel. And that is dramatized in the film. Well, Jeff Smith was my guy on The Bridge of Spies. This channel lay dormant for more than 20 years until Jeff stirred it up again. So I'm going to ask him to start this program by telling us how the channel came alive and what came of it. Your floor, sir.
Well, thank you, Mark, and it's a treat to be interviewed by you and to see, at least indirectly, a lot of old friends and to discuss these three subjects that are, I think, both interesting and important. First, on the spy trade business. In the 1977, the Soviets arrested a man named Anatoly Sharansky, a Jew who was a prominent opponent of the regime, and charged him with espionage. And a group of American Jews and Israeli Jews had been trying to get Jews out of the Soviet Union. And so they approached Wolfgang Vogel, the lawyer in East Berlin you mentioned, who had done the Powers-Able exchange in 1962. And Vogel said, well, I can't get you Sharansky, but if you can get Thompson out of jail in the United States, we might be able to work something out down the road. And certainly there are some people that you want in the East. And so it arrived on my desk. Jeff, if we want to get somebody out of jail, how do we do it? And so I began to dig into this, of course, and find out what the deal was, which was the basic outlines of this first spy trade had already been arranged by Vogel, but it was brought to the State Department because we had to actually implement it. Thompson was an American citizen, had been arrested in 1965 in this country for having spied for the Russians, and was given a 30-year sentence. He was not mentally very stable and was a highly unsuccessful spy for the Russians, but nevertheless, he was a spy and he was convicted. And the Russians wanted to get him home, back to Russia. So the question was, how do we get him out of jail? And how do we get him to Berlin for the trade? And we were going to get a young man, an American named von Norman, who had tried to smuggle people out of Eastern Germany. So I talked to the Justice Department and they said, well, we're happy to parole him, which is to say release him, and we'll bring him to JFK Airport and then you can sign for him and take him. And I thought, well, that's okay, but how do I get him there? And surely you're going to have a marshal or an FBI agent go along, because the Bureau had told me that Thompson was not mentally stable. He'd been in prison, federal prison, for all those years. And Vogel, by the way, flew to the United States, and Vogel and I were going to take him back to Berlin. And I had the presence of mind to ask Vogel what class he was going to travel in. And he said, Erste Klasse natürlich, first class, which meant I had to get special permission to fly first class. And then I was dismayed when I learned that neither the marshals nor the FBI would be going along. So I worked with Pan Am and arranged that in first class, Vogel would sit on the aisle in front of me, and Thompson would sit next to him in front of me, and I'd sit at the window. And then, because I thought, well, what do I do? Here's somebody who's been in prison all these years. Some very attractive Pan Am stewardess is going to show up, hand him a drink where he hasn't had a drink in all those years, and the Lord knows what's going to happen. So the Bureau said, look, Smith, you're on your own. So as you mentioned, Mark, I'm an old Army Ranger, so I went to the hardware store and bought about 40 feet of nylon rope, because that doesn't stretch, cut it in half and wrapped up about 20 feet in the, put it in each pocket on my suit jacket. And I thought, if Thompson misbehaves, the least I can do is tie him to his seat in first class until we get him to Berlin. Thompson was well behaved, as it turns out. I didn't have to practice my garroting technique. And we eventually, about halfway over, got up and walked around the airplane, and Pan Am had put their own security guy in, some fellow who looked like an NFL lineman standing in the galley. But the important point is that went off without a hitch, and that opened the Vogel Channel then.
Oh, that's excellent. Wonderful story. And I was thinking of you because I knew this story. Last night, Mimi and I were watching Air Force One. Harrison Ford.
Well,
flying off the end of the plane, and I could imagine you with your karate chops. Well, why don't you give us an overview of where the channel? I know that the treasure at the end of the road here is Sharansky. That this, once you were able to get the Vogel Channel open, eventually that led to the release of Sharansky, which was a matter of great importance to the United States, the dissidents in the Soviet Union, in Israel, and around the world. But give us an outline of how the mechanics of this went. How many visits did you make with Vogel? How many visits did he make to Washington? Where did you meet? Who were the people that were involved?
Well, what happened was after this first deal, Brzezinski, who was then the National Security Advisor to President Carter, got interested and realized that there were a large number of people in Eastern Europe and the Soviet Union who had spied for us, who were languishing in jails, and we hadn't made a concerted effort to try to get them out. So we did put together an interagency group. We also talked to our friends in Europe, particularly the British, the French, and the West Germans, who also had people both in their prisons and people they wanted out. And so we began to work this Vogel Channel. And I'm not sure how many trips to Berlin, at least a dozen in the ensuing years, met with Vogel frequently, and we began to work out individual trades. As you say, ultimately it led to the release of Sharansky, but what was important in all of this, Mark, is that Sharansky was in fact not a spy for the United States, and we never wanted to acknowledge that by listing him among the people that we were prepared to trade. But Vogel knew, the Russians knew, everybody knew that Sharansky was extremely important to us. So I'm not sure how many trades occurred in the interim. Some I participated in, some were done directly by the East Germans and the West Germans. But you ask about the modalities of them, and I would go to Vogel with a list of people in rank order of who we regarded as the most important, down to the one in whom we had the lesser interest, least interest, and he would do the same. And we would meet often in his office in East Berlin, or he came to this country a couple of times. But when we met in his office in East Berlin, he would never use any names. We would just sit at a table in his office, and we would sort of tap on the piece of paper to different names, and we would say eine große fish or a kleine fish, a big fish or a little fish, and we would sort of say, well, 2 for 3 or 1 for 3, or there was some balance of the relative importance and the willingness of my Eastern European colleagues and my Western clients to see what the trade was, what made sense. And eventually we did, eventually we were able to get Sharansky, and you asked how we did this. So I will, in the interest of time, sort of move toward that. But one brief story I think is important to say in the meantime. toward the top of our list all along was a man named Saretsky, who had spied for the United States for any number of years in East Berlin and provided an enormous amount of valuable intelligence. Vogel told me that he was in terrible shape, all kinds of terrible physical problems. And so finally, in 1983, we arrested an East German in Boston named Zehe, and Vogel contacted us and said, well, if you can get Zehe out, and if you let me come to Washington, I can get you Sharansky. And that was the first time we heard that we can get Sharansky. So Vogel came here. We met in, of all places, a bar in the Hyatt Hotel on Capitol Hill where he was staying, which had the name Spy's Eyes, which I chuckled at. I had no idea it was. I don't frequent bars on Capitol Hill, Mark, so I didn't know what it was. But we met there, and he gave me a list, and it was everybody in Eastern Europe plus Sharansky. We had for a long time, we'd been pursuing Russians, but we never got any Russians out, frankly. We later learned that both one had been executed and the other had committed suicide with a poisoned fountain pen that he'd been provided. But we kept insisting, trying to get them out. So that was in December of 1983, Vogel came here. And I said, of course, we want all of these plus Sharansky, absolutely. And Vogel said, fine. So Vogel flew back to Berlin. I reported all of this to Secretary Schultz, who said, Jeff, would your family mind if you missed Christmas? Aloud as how they probably would. So on the day after Christmas, 1983, I flew to Berlin, had a series of meetings with Vogel, and sadly, he wasn't able to deliver. But he promised that he would keep working on it. As you know, then I left the legal advisor's office in March of 1984 to go work on the Hill, but the deal kept cooking. And finally, in 1986, we were able to get everybody out of Eastern Europe. I mean, it was a bus full of agents, assets, as we say in the intelligence business, who had spied for us in Poland, East Germany, Czechoslovakia, and perhaps other places, plus Sharansky. And that deal was finally done by Rick Burt, who was then the Assistant Secretary of State for European Affairs. Well, we finally got Sharansky out.
I must say that it must be thrilling to be an actor in that episode, which is so significant, and it's still resonating.
Well, it is. I want to make one final point about Saretsky, Mark, just very quickly. We got him out in 1983, and when we thought he was in terrible shape because Vogel had told us all of these things that he had problems he had. Well, he bounded across the line, and I got in the car with him and said, well, we're going to take you to the American hospital. And he said, why? And I said, well, we were told you had all of these problems. Oh, no. He said, I was just making all of that up, bad stomach, bad back, so forth, nerves, headaches. And I said, why? Really? And he said, well, I am a Prussian and I hate the Russians. I thought that's the kind of person we want spying for us.
Well, before we leave this topic, I'd like to ask you, what do you take away from this? What is the significance, the larger significance, the message you would, what did the United States government learn from this experience? And what's going on today? The channel lay dormant for 20 years. But I imagine there's a residue of it now. What's going on?
Well, I don't know, Mark, what the current exchanges might be, but clearly the trading of spies is a long practice. There are a couple of things to say. One is, as Brzezinski pointed out, it's really important for the United States to make it clear to anybody who's willing to risk their lives, frankly, to be our source in a hostile country. We have to stand by that person. We have to do all we can to get him out, get his family out. Secondly, that gave us a little bit of a window into what was going on in the Soviet Union and Eastern Europe. We began to see some cracks in the system when we got everybody out in '86. What's going on today is, of course, in 2010, there was a very big exchange with something like 10 Russians that were arrested in this country, and then we got 4 people out of the East. But you and I have talked about the risk in all of this, which is that countries would just grab somebody as a hostage for purposes of trading them. And that really is dangerous. And we've seen a lot of that in the Middle East, as you well know.
Well, we're going to come back to that when we talk about the Iran-Contra scandal.
Yes.
And we see it frequently in the papers today. It's even a political issue in US politics. When there are people, Americans, who are taken for purposes of ransom, and naturally the families and the political are deeply concerned about it. There are other situations where when the United States or a neighbor arrests someone for violation of law, that a foreign country may seize a national of a U.S. national, or as in the case of Iran, or a national of that neighboring country or allied country as a means of pressure. How do you make these trade-offs? And do you think that there is any connection between the practice of protecting our own spies abroad, a practice reciprocated by the Soviet Union in your experience? Is it a mixed blessing, this whole history?
It is a mixed blessing, and there's no clear moral line here, Mark. If it's literally a spy for a spy, that's a professional understanding among intelligence services. Where it raises these moral questions is where it begins to slip over into people grabbing innocent persons just for hostages, or arresting people and charging them solely for the purpose of trading them. And there's no clear moral answer here. You have to just look at each one and try to make a judgment.
All right. Well, it's an exciting story, but we can come back to this at the question. Maybe the folks who are listening will have additional questions to sharpen our discussion at the end of the hour. Let's move to another part of the world, across the ocean to South Korea. And I know I have a student who may be listening to us now who works for the government of South Korea in the reunification bureau of that government. So we're going to talk now about the trial of Kim Dae-jung. And I already mentioned that he was president of South Korea from 1997 to 2003. But you met him in 1980, if I have the date right. Tell me the circumstances.
Yes, I did. And it was one of the more significant things I was able to do. And I'm proud of what the United States did and my little piece of it. Kim Dae-jung was, as you mentioned, a prominent advocate for democracy and reunification and the rule of law for his whole career. And in the fall of 1979, there was a coup in Korea, and General Chun Doo-hwan took power and declared martial law. And there were a series of riots in which Kim Dae-jung gave some pretty fiery speeches, frankly, and violence occurred, and particularly in a city called Gwangju, something like 200 people were killed by the army. And the military leaders, particularly Chun Doo-hwan, thought that Kim was responsible. And so they put him on trial in a military tribunal, charged him with sedition and inciting riots, and he faced the possibility of a death penalty. And that started in September of 1980. And the American embassy in Seoul would sent some people to attend the first couple of days of the trial, but then decided that they wanted, frankly, a lawyer to come over and be the observer at the trial. And so I was asked to take that on and was happy to do it. So I flew to Seoul and spent 7 weeks in Seoul attending the trial, which there were usually 2 or 3 sessions a week. Obviously, I don't speak Korean, so the embassy provided me with an interpreter for the sessions. And then on other days at night, I would go out and visit either with counsel for Kim or meet with dissidents. And we sent back a whole series of reports. Clearly, there was no real evidence against Kim that he had committed or incited a riot. All of his speeches, we had the texts of those, even the newspaper articles that were introduced. He was calling for democracy in elections and getting rid of martial law. He didn't incite anything. But what was clearly at stake for the United States was to champion democracy in Korea. And because the South Korea and the Korean Peninsula is enormously important to us as a strategic point of view. And the best way to assure stability in South Korea is democracy, and to assure that they were a good ally. Keep in mind, we had a huge number of American forces in Korea across the DMZ from a very belligerent North Korea. So stability in the South and avoiding a war on the peninsula was hugely important. And to move forward a bit, my reports going back to Washington were, of course, interesting to me and for people to read. But one little incident is worth perhaps mentioning. There were a lot of reports about dissidents being beaten, and one volunteered to meet with me. And so I met with him in a hotel in Seoul one evening, and he said, "I've been beaten." And I said, "Yes." And he said, "On the back of my legs, do you want to see my injuries?" And I said, "Yes." And I, of course, had somebody from the embassy with me. So he dropped his trousers and showed me the terrible bruises, horizontal bruises, all up and down both legs, where he had been beaten with a truncheon. And you could clearly tell it was very painful. And that was the first bit of really hard evidence we had of abuse of dissidents by the new regime.
Well, as you were watching the trial, how was it going? Was it any semblance of justice as in process-wise? How did you think it was going to come out?
Mark, there was no justice in that courtroom. It was clearly foreordained. It was a military tribunal conducted on the headquarters of the South Korean Army in Seoul. There was no real evidence against him at all. And it was pretty clear he was going to be convicted. The only question was, would he be sentenced to death? And on the day he was due to be, the verdict was to be announced and the sentence announced at the same time, by the way. I showed up and I was sitting in the front row on the aisle in this courtroom, probably about 40 people permitted in the courtroom. And it was not a very elegant courtroom at all. It was sort of an army barracks feel to it. But Kim stood up, and when he was pronounced guilty, there was kind of a murmur in the room. And then when he was sentenced to death, there was clearly just this gasp. And there were several members of his family there, as well as his supporters. And we were told to sit down and be quiet, stay quiet, until he was led from the courtroom. And so they then put him in shackles, hands and feet, and he was shuffling out of the courtroom between two big South Korean military policemen. And when he approached me, Mark, he stopped and he bowed to me. And it just took my breath away. And then the military policeman kind of stumbled, and then they just forced him to keep going and out of the courtroom. And when he finally got out of the courtroom and things settled down, I went outside, and Kim's family and supporters were standing there singing Korean. And it was really a powerful occasion.
That's pretty dramatic.
So it was very dramatic.
To you that you were assigned to this, and what an experience to have in a career. I'm going to ask you, of course, we want to hear about the denouement of this. But what was going on? What was your perception while you were in the trial? What was the kind of vibrations around your presence there? I assume it was conspicuous and noticed. Did you notice any impact on the proceedings?
No, that they clearly knew I was there. I had asked to meet with Kim's wife. They refused that. I met with his defense counsel 2 or 3 times. The prosecutor refused to meet with me. I was staying in a nice hotel in Seoul, but I would go out for a walk at night, and I was always followed by 2 or 3 very obvious CIA people who tended to all wear blue suits and white shirts with no tie. So it was very clear to me that I was being heavily surveilled and under some pressure.
What were U.S. relations with the government in Seoul at that time? And what kind
They
of
were strained.
What kind
They
of
were very-
demarches were we making to them about this trial?
I don't know that we made any demarches during the trial that I can recall. I do know that we were clearly putting pressure on the South Koreans to hold elections, and we were opposed to martial law. We wanted that lifted as soon as possible. And part of the explanation, or part of the plan, was that I would come back to Washington, my report would be released publicly, and I would probably testify before Congress and maybe at a press conference or something, just to demonstrate that this was a complete sham. But this was the tail end in 1980, the tail end of the Carter administration, and Reagan had just been elected. And both the Reagan and Carter administrations recognized the significance of Kim's trial and his conviction. And so they cut a deal in what I think is a very good bit of bipartisan, thoughtful, long-term diplomacy and strategy. The deal was that my trial report would never be released. We would not criticize the Koreans for the trial and the sham conviction. Chun Doo-hwan would be the first foreign visitor to come to the White House to meet with President Reagan. And in return, the Koreans would eventually commute his sentence and let him leave Korea. And that's precisely what happened. Kim was able to leave Korea, initially to Japan, then came here, eventually went back to Japan, went back to Korea, was rearrested. Again, the United States put great pressure on him. And as you said at the beginning, eventually he was elected president in 1997. And really democracy was restored in no small measure because of the pressure of the United States and clearly Japan and others who have a great interest in South Korea. And I was proud to have some little tiny role in all of that, because think what South Korea would be today if it were not a democratic, vibrant state with a strong economy, a strong military, and a vibrant democratic government. It's just made the region much more stable. I mean, it's dangerous, but South Korea is a vital ally of the United States. And I think this just demonstrates that the United States is really at its best when we have these goals in mind, which is diplomacy, the rule of law, and democracy. And I think it has worked very well in the case of South Korea.
Well, it's great that you could participate in that and to represent the United States at its very best. You know, one thing we haven't talked about that occurs to me as you tell that story, the importance of a normal, traditional transition between two elected administrations in the United States, where we can have continuity of foreign policy and a common purpose in the world and maintain, protect the vital interests of the United States. We haven't had that in the most recent transition. And we're going to feel the burden of that for a long time to come, I'm afraid.
Yes.
Well, that brings us to another transition. And I was the acting legal advisor in the Carter-Reagan transition. You may remember that. And that happened because everyone who was more senior to me in the legal office, and of course elsewhere in the government, was fired on the night of the Ronald Reagan's inauguration. Or I should probably say automatically at noon that day. I think we concluded the last of the first round of the series by my describing the situation in the White House as we were waiting for the hostages finally to the American diplomats held hostage in Tehran to be released by Khomeini, and that didn't happen. They deliberately withheld it until baton passed from Carter to Ronald Reagan. So with the election of Ronald Reagan came a really major change in American foreign policy. It was across the board. Reagan had campaigned against the Panama Canal Treaty, for example. There was a lot of, during the extended negotiations for the release of the American hostages, there was a lot of tension between the two political campaigns. And the Reaganites were very concerned about whether the Carter administration would arrange an October surprise. And there were some suspicions, and there's been much debate, whether the Bill Casey, who we're going to talk about and you're going to talk about in a few minutes, was arranging, had made some kind of an arrangement with the Iranians to delay the release of the hostages until the election in November of that year. And there's this is still under debate, and it hasn't been established, but there's a lot of people believe that is the case. In any event, there was one of the major pieces of changes in the foreign policy of the United States upon the election of Ronald Reagan was the commitment of the new administration to what became known as the Reagan Doctrine, to take active measures, in the phrase that can be loaded sometimes in your intelligence world, to prevent the spread of communism in the hemisphere. And I was, being acting legal advisor, I was the one who had to tell the Secretary of State, Alexander Haig, that the Carter administration had actually been cooperating with the Sandinistas in Nicaragua, who had taken over the government. This was a very Marxist force that had taken over the government from Somoza. And all of this was important background to the next topic on our agenda for today, and that is the Iran-Contra scandal. And what this involved, very briefly, as Jeff is going to tell us how this unfolded, was an undertaking by the Reagan administration to trade arms, to provide arms directly and indirectly to the government in Iran, which had taken our hostages, in order to try to release some American citizens and government employees too, I think, who were being held by the Hezbollah in Lebanon, which was closely tied and supported then and now, connected to the Iranian government. So it had two elements: sale of arms to Iran, which was because of the hostage taking, under an arms embargo from the United States. And I have to say, this was a secret deal. That's of the essence here. That's why it became a scandal. But with two elements. One was to sell arms, to provide arms to Iran in exchange for hostages, and to provide the proceeds of those arms sales to finance the Contras, that is to say, a guerrilla force funded and helped by the CIA, trying to overthrow the Sandinista government of Nicaragua. And the problem and the reason that this was secret was that both sides of that policy were against US law. I think with that introduction, please tell us how this unfolded, because you found yourself, just as in these other cases, in the middle of it.
Thanks, Mark. You've summarized a very complicated set of facts well. By 1986, the Reagan administration had set up this arrangement in which they were raising private money from American citizens and others, and from other governments to fund the Contras in Nicaragua. And they did that because Congress had specifically prohibited the use of American funds to support the Contras with something called the Boland Amendment. And Reagan didn't like that. He told his staff, I want you to do everything you can to keep the Contras alive and well. And so they went out and raised all this other money. And initially, they were providing that secretly to the Contras with a sort of a private army organized by a retired Air Force General Secord, who was cooperating with the CIA, and they were flying supplies into the Contras. Then later, in about 1985, the Israelis approached us and said, we think that if you let us sell some arms to Iran, you can get the hostages, the American hostages out of Iran or held by some of the Iranian groups in the Middle East. And over the objection of Schultz and Weinberger, the Secretary of State, Secretary of Defense, Reagan approved that arrangement, and that began the sale of arms to Iran. Congress was told of neither activity, nor the private fundraising to support the Contras, nor the sale of arms to Iran in violation of the embargo. So as you say, it was secret, and both probably were in violation of the law, but that didn't bother Reagan, Poindexter, McFarlane, Ollie North, and the rest of that gang. It all came apart in the fall of 1986 when one of General Secord's airplanes crashed or was shot down in Nicaragua, and he was captured. And suddenly people said, what's going on here? What's an American doing flying supplies to the Contras? About the same time, a newspaper in Beirut leaked that the Americans were selling arms to Iran in return for hostages. Well, that just, you can imagine the uproar. So by this point, I was working up in Congress for Senator Sam Nunn, and he was chairman of the Senate Armed Services Committee. And so Congress decided that they would have to investigate all of this. And I had known about the support for the Contras back when it was legal, because it had actually started initially in the tail end of the Carter administration, but then it got stopped by Congress in the Reagan administration. So I was, and I was also Senator Nunn's designee to the Senate Intelligence Committee. Congress formed a joint committee, which is highly unusual, between the House and the Senate to investigate all of this. And I was designated to be one of Nunn's staffers to this committee. So I found myself on the committee staff investigating all of this. By the way, individual witnesses were assigned to individual senators, and Senator Nunn's witness was John Poindexter, who was the National Security Council advisor, National Security Advisor. And one of the key questions was, how much did Reagan know? What did he approve? And did Reagan know particularly about the diversion of money? Because Ollie North and gang decided to increase the price of the arms that were being sold to Iran, some by Israel and eventually directly by the United States. And they generated millions of dollars of profit, which they then used to give to the Contras, although they also kept a lot for themselves, as we later found out. But it was just a really horrible, ugly scandal. So the committee was established, but before the committee was established, there's one other brief point I'd like to make. Congress began to hold hearings on this even before the joint committee was formed. And one of the witnesses that was called was Director Casey, who was the director of the CIA. And he was to testify before the Senate Intelligence Committee in their, what's called a SCIF, which is a secure room. And because I was Nunn's designee, I was in the room at that point. So in December of 1986, Casey comes up to testify. And Casey's in the middle of all this. He knows everything. And he shows up, and Senator Robert Byrd, who's the minority leader, is a member ex officio of the committee. So he came and he said, I think we need to put Casey under oath. Senator Dernberger from Minnesota, Republican, was chairman of the committee, and said, no, we never do that. We don't need to. Casey said, oh, I'll tell the truth. So we proceeded. And then Casey proceeded to lie. He said the shipments to Iran were not weapons, they were oil drilling equipment. And thinking that would be the end of it. Well, of course,
Was this in private testimony or was this public?
no, oh no, it was highly secret, Mark. It was in the SCIF.
I'm sorry, yes, of course.
So it was secret testimony. And that was the cover story, that these were not weapons, these were oil drilling equipment. But what happened was Abe Sophir, who was the legal advisor at the State Department at the time, knew something about what was going on because Schultz had kept him informed. And they were really upset by all of this. And Sophir then decided to call the Attorney General and wound up talking to the Deputy Attorney General. And they then began an internal investigation. And then the administration realized what was going on. And so I think the Office of the Legal Advisor did very well in that episode. But
before we go further into the investigations and the reports of the Joint Committee, it might help the audience, those of you who don't remember some of the detail. There were two very volatile political issues, very damaging to the Reagan administration. And the first of the one I think that commanded the most attention publicly was that it was a very forcefully stated policy of the United States government that we would never negotiate with terrorists. And this had a lot of implications for people who were kidnapped or hijacked and who were suffering. It was very controversial. Families and businesses paid a price for this, and it was widely understood. So that leaving apart the legality of all of this, it was a violation of the public trust, and neither the administration and particularly the president did not want to admit that they were actually doing this. So not only was it secret, but they, at the time frame that you're talking about, they were denying it publicly, right? So that explains why Casey was going to lie about it. And of course, maybe by this time you also had the point that the Boland amendment had been passed, which made illegal the transfer of funds, arguably illegal the transfer of funds to the Contras. And here I think as a law teacher, we use pages of the report that you're going to describe to present an issue. The Reagan administration, and it's, as far as I know, you can correct me if I'm off on this, as far as I know, all the witnesses before the Joint Committee investigation that you're going to describe maintained that the government, the administration had not violated the Boland amendment. But that amendment prohibited the use of any appropriated funds to support the Contras. And there was also a legal issue whether the Congress had the constitutional authority to constrain diplomacy by the executive branch. In other words, the minority on the committee took a theory of the unitary president, the plenary power of the president in the conduct of foreign affairs, and Congress, they argued, could not constrain the conduct of diplomacy. And therefore, to the extent that there was an alleged violation based on the diplomacy leading to the funding from sources that did not go through the Treasury, that this would have been legal as a matter of constitutional law because the statute they claim was invalid. So these are pretty fundamental issues. So I'm sorry to interrupt you, but I thought that might be helpful. Tell us how the Joint Committee proceeded.
Well, it was one of the more frustrating, thank you, Mark, and I think we might want to come back to this issue of the president's powers because we saw that in particular focus in the Trump administration. But the committee was one of the more frustrating things I've worked on. First of all, it was a very large committee. Secondly, the leadership decided that they would conclude all of this investigation by the end of 1987. So we had less than a year to do it because they didn't want any of this spilling into the election year of 1988, which was a presidential election year. So things were at an incredible pace. We put witnesses on not knowing what they would say. We deposed a lot of them beforehand, but the depositions were hastily done before we had a lot of evidence to ask them questions about. And there were a lot of questions were something a lawyer should never do. Members of Congress were asking witnesses questions to which they didn't know the answer. I mean, they were just pulling things out of the blue. And I can cite a couple examples of that if you're interested, but I won't, but they're interesting. And so that was one thing. Another thing was we determined at the outset that this would be televised, we, the committee, determined that it would be televised live. And there was a ferocious amount of interest in all of this, including what did the president know? Did Reagan know all of this was going on? Because there was hanging over him the threat of impeachment, obviously, if he had done all of this. Because everybody, with a handful of exceptions, thought this was terrible, illegal, a bad idea. Particularly the diversion, the idea that you would actually divert money and then pocket some of it. That was just too much for everybody. But as a result, we hurried things along. The schedule of the committee, we would televise these hearings during the day. We would take commercial breaks, Mark, so that the networks could hold commercials and they wouldn't lose revenue. So we would periodically take breaks, just like in a football game, you know, they have a TV timeout, we would do that. Secondly, I remember Senator Noe, who was the ranking Democrat on the committee, assembled all the key staff before we got started, and he said, "Now remember, you're all going to be on television, but we want you to keep a particularly close eye on your senator. And if he, they were all men at that point, if he starts to fall asleep, but just make sure you nudge him, wake him up, and so we don't want to have any images of senators falling asleep on television." So that we did, and it was an absolute zoo, just a complete circus. And as I said, we put people on not knowing a lot of what they would say. And because much of the interest was what did the president know, Poindexter was a key witness. And we knew in advance he was going to say, well, the president really didn't know about the diversion. We kept that from him. And we also knew he was going to say, well, the president made some mental findings, which is required under the law in order to do covert action.
What do you mean by a mental finding?
Well, he just decided in his head. He didn't know, it was not written. He didn't sign anything, which was supposed to be.
This was their stated position?
Yes, it was a mental finding.
Is there some legal significance to a mental finding?
No, they just made it up. I mean, they just conjured it up out of, there was no basis for that at all. They just decided he was the president, and he decided he could do this, and so we did it. All this kind of stuff came tumbling out. But when Poindexter testified, the president didn't know and didn't approve all of this. TV ratings just dropped. People stopped coming. The TV channels went back to their soap operas. The whole thing kind of wound down. The other thing is two things that lawyers would appreciate. One is Ollie North's lawyer, Brendan Sullivan, did a fabulous job of agreeing that he could only be deposed about what President Reagan knew. He couldn't be deposed about anything else. And he played rope-a-dope with us. He knew that the clock was in his favor, not in our favor. So we put Ollie North on, not knowing what he was going to say, except that he didn't know what the president knew. He assumed the president knew all of this, but that was up to Poindexter to say what the president knew. So North was answering questions. We didn't know what he was going to answer. At one point, Senator Nunn said, "Did anybody offer you a bribe?" And he said, "Yes, Gobonifar offered me $1 million bribe." That's a federal crime. We said, "Okay, thank you very much." Moved right on. I mean, just the whole thing was just typical, Mark, of what was going on.
Now, this was happening in an environment where you had now, when Reagan was elected, I take it you were a minority council. There was
Yes.
the Democrats were in the minority in the Congress, but by this time they were in the majority.
That's correct. I was,
The election
yes.
of 86. So I think you're describing a process where there was no cooperation between the minority and the majority in the conduct of this investigation.
No, there was pretty good cooperation on the actual investigation, Mark, in terms of who was called and so on. But the real problem was the pressure of the election to get everything done. So we granted use immunity to a large number of witnesses, principally among them Poindexter and North. And so when we were finally done, we granted use immunity, which for the non-lawyers on the call means that no use can be made of what their testimony is. If they're to be prosecuted later on, the Justice Department has to find independent evidence of what they did. They can't use what they told the Congress. Justice said, don't do that, you'll screw up our prosecutions. And the Congress said, no, it's too important to get out what happened here. So we're going to go ahead and grant them use immunity. And sure enough, when it was all said and done and the special prosecutors came in, Joseph Welch came in to lead the prosecution. As you know, Mark, he wound up indicting and charging some 14 people. But in the case of two of them, Poindexter and North, both of whom were convicted of various crimes, obstruction of justice and so on. But ultimately, their convictions were thrown out by the courts because the witnesses against them could have been influenced by their public testimony that Poindexter and North had given to the committee. So sure enough,
I think we need to clarify at this point that you have two separate procedures and they were sequential, if I understand the situation. First, you had a congressional investigation before the election, which was conducted by a specially created joint committee. And just in the Senate, or was it also in the House?
No, it was a joint committee between the House and the Senate.
And you had an outside counsel, Arthur Lyman was appointed to conduct that. And the outcome was a big, can you show the report? Do you have it at your fingertips there?
Yes, I do. Yes.
How many pages is this thing?
It is very thick.
This is the
I'll give you a sense.
the
Sorry
result
for the lighting. It is
investigation in which Jeff was involved. And it has a majority report and a minority report, a dissenting report, right? And so there was a minority report, and I know from my teaching that there were serious disagreements about the Constitution that we're going to come back to. But were there not also differences about the facts of the situation?
I don't remember a lot of differences about the facts. It was sort of how more on the emphasis of why was supporting the Contras important. Nobody really supported selling arms to Iran. Nobody really supported the diversion, but the support for the Contras still had a lot of support among conservative Republicans.
Right.
And remember that Richard Cheney was the leading Republican on the House side, and this theory about the unitary president comes out strongly in the minority report, and that the president really is unconstrained in his foreign policy powers by the Congress. And so he doesn't need to tell them anything, and all they should do is give him money and get out of his way. That's an oversight.
That's the issue that I want to talk about later. But now the next thing and I interrupted you, for which I apologize. Following the conclusion of this, if I have it right, a special counsel was appointed. And how did that happen? And was it the Justice Department or was it outside? What kind of?
No, it was an outside special counsel brought in, and he conducted a thorough.
Was it by statute, that procedure?
Mark, I honestly don't remember.
Sorry, we didn't really talk about that, but it's interesting in the light of the recent debates about special counsels, the Mueller report and so on. And they launched all these prosecutions, and the prosecutions were generally successful. but with
Yes.
the signal exceptions where the immunity got in the way. But did anybody serve time? One guy, I think. Out of
One former CIA officer was the only one who served time. All of the people in the administration who were charged with crimes, McFarland and others, were pardoned. Secretary of State Weinberger, Assistant Secretary Elliott Abrams, were all either convicted or pled guilty and were subsequently pardoned by President Bush. So
yes, that reminds me, when I heard Alan Dershowitz talk about the Trump's entitlement to pardon anybody in his administration and how that couldn't be interference with dangling such a thing, if I recall what he said accurately, could not amount to obstruction of justice, because the president could not commit any kind of an offense when he was exercising a power such as provided by the Constitution, such as the pardon power. And it all goes back to this exercise. This is by George Bush the first, the father,
yes.
who issued these pardons on the advice of Bill Barr, if I have got this right.
Yes.
So that you see a lot of roots here, or it's more than seeds. It's root and branch. Really. This is where we were harvesting some of the fruits of these theories of untrammeled presidential power that came to fruit under at your time. But you were going to conclude by talking about what your takeaway was from the point of view, the catbird seat of being on the, you had been an executive branch lawyer, and you in the State Department, your CIA years were still ahead of you, but now you had the experience of watching this whole process from the seat at the Senate table. Tell us what your thoughts are about how the Constitution works in this area.
Well, I'll do that very quickly, Mark, because I know we have some questions. But essentially, I came away from all of this thinking that the founding fathers were really quite brilliant, and they understood that to govern was a struggle for power, and the balance of power is just essential. And Congress, at the end of the day, represents the people, and we really are at our best when we do adhere to these basic principles, when we compromise, but we keep the principles foremost in our mind, particularly the rule of law, the importance of democracy, and decency and respect for one another. And we've seen not as much of that as I would have liked, particularly in the last few years.
Thank you, Jeff. Maybe we should move on now to some, bring the audience into this. If I can begin, I want to read a remark by one of my students, Ryan, and I say his name is Mr. Park, and I can't pronounce his first name, so we call him Ryan. And he's saying to you, thank you for securing the critical seed of South Korean democracy. Kim was a giant in modern history of the Korean Peninsula, as well as South Korea. I decided to become a government official while watching the first inter-Korean summit between Kim and Kim Jong-il. It is sad that there is rare democratic seed in North Korea for 7 decades. Anyway, my question is a kind of alternative to clarify the importance of the US and your role in the trial. What do you think would have happened if there had not been US observation and intervention in the course of that trial? Would Kim have lost his life? That's
a very poignant question. Quite possibly, yes. There was no question that there was very heavy US pressure, Japanese pressure, British pressure on Chun Doo-hwan and his new military junta. And I would like to think that my presence just made that visible in a way that they couldn't ignore. And I cling to this image of Kim being taken out of the courtroom and bowing to me. He wasn't bowing to me, he was bowing to what I represent, which was the United States and what we stood for. And I think he may not have survived, and most likely would have been executed, but for the pressure of the United States, particularly. And I think I had some modest role in helping that.
Oh, that is marvelous. We're all proud of you and proud of our country for that episode. Now, I have another comment here, and a gentleman named Christopher Bailey has said that you would be remiss if you did not mention David Addington's role in preparation of the Senate Minority Report. And Addington was active in the Bush years, as I recall.
Well, David, somebody I've known for a long time. He was a CIA lawyer at one point, among other things. He is a very smart, talented lawyer. And he then was Dick Cheney's, as I recall, his lawyer for the Iran-Contra hearings, and later wound up, when Cheney was Secretary of Defense, he worked for him. And then when Cheney was vice president, he continued to work for him and was one of the architects of the enhanced interrogation program and the detention of prisoners of war in Afghanistan, in which I think we made some very major mistakes. So I think David is very smart, but he does not think highly of international law.
Well, I remember that there was a book written by some important scholars, really serious people. I think Jack Goldsmith was one of the authors, and one of the Posners was the other author, in which these scholars said, contrary to what we were taught in the legal advisor's office and what we preached there, that, and this was shocking to me, that international law, that when the United States government was doing options papers, pros and cons, what are the US interests, maintenance of international law or compliance with international law should not be weighed as a national interest. That is a debate through the ages. But the other issue, the one that I think that we've talked about that is so much more profound in its practical application, is what is the relevance of the US Constitution? And every year I teach a course in foreign relations law. This may be my last year doing that. I've got some great colleagues who are going to take it over. But the thing that we debate is how are foreign affairs authorities allocated by the Constitution or under the Constitution, since there's little in the text to guide us, between the president and the Congress. And every lawyer who works in government on these issues participates according to the interest of the perspective of his or her agency in that ongoing debate to which there is no definite answer. But we see in the Trump administration the fruition of a philosophy which was present, I think we have to acknowledge it, here in the Iran-Contra scandal, that the Congress has no legitimate role in constraining the foreign policy of a newly elected president. The president, they feel, has I want to say is entitled to act like a king, but that's an argument, that's a tendentious way of describing it. The theory is really, I think, not only did the president of the United States, Donald Trump, believe this, but I had a strong feeling that his Attorney General, William Barr, really believed that the Constitution entitles the president to do whatever he thinks is necessary in the conduct of foreign policy. And he has no obligation to share that responsibility, and has no obligation to share information with the Congress. And you could say that this spirit, one could argue, had its fruition in the riots of the attack on the Capitol on January 6th. But I want to hear, I think our audience wants to hear your perspective on that more than mine. So why don't you, we only have 5 minutes left in this session.
In 1 minute, Mark, that may be, there may be legitimate arguments on the side of the unitary president. I don't happen to believe them, but as a practical matter, in almost every instance I've been involved, the president's ultimate ability to achieve something is enhanced when Congress is with him. when he ignores the Congress, when he stiffs the Congress and goes off on his own, almost always it's a mistake. And Congress has the power of the purse. Most American people don't like it when the president goes off and does something on his own without talking to Congress. And he benefits from the advice, he benefits from the political support he gets by having the Congress with him. And so just as a practical matter, it is foolish to tell the Congress to, use a non-legal term, go pound sand.
Yeah, I'm taking a break to say hello to Jim Michael, former colleague of ours. And so I'll do it on camera. Nice to have you. Thanks for attending. Do you have any final words? There is one other, we have 3 minutes, and there's a question that we got before the session. I'd like to conclude on this, and I'm sorry we can't handle all the questions that we've had. Someone asked, how can lawyers not employed by the government work to support attorney diplomats? And I would expand that or restate it to say, how can folks, not just lawyers, but citizens outside the government support the kind of objectives that lawyers in government that we're preaching is the role and purpose of service in government. So why don't we conclude by saying how the public can support integrity and sincerity and ethics in government service?
Well, that's a very good question, and it's really brought to light by the events of January 6th, because I was just shaken to my core by what I saw. And these were people who claimed that they were advocating for the Constitution, the rule of law, and nothing could be further from the truth. And it has to start with leadership in the executive branch, leadership in Congress, leadership at the local level to explain what our Constitution means. It is a process. It is a matter of consultation and cooperation. And we do not have a king. And we came very close to a coup. I mean, I think it never would have happened, but that's what those folks were trying to do. So I think at this point, it's a question in my mind of education, of leaders at all levels in our society, public, private, leaders of faith, leaders in academia, getting back to the basics, talking about what our Constitution is and what it means. It just appalled me to think that these people thought at some distorted, twisted level, they were calling for what they were doing was right and was supporting the Constitution. That's just a frightening thought. And we've got to get people to understand that nothing could be further from the truth. And we have a lot of work to do.
That's a perfect conclusion. And I will put the emphasis on the word education. And there's a lot of concern that the curriculum in schools at all levels, high school and college, that we need to return the basic curriculum to orient people, training how to be a citizen, to understand how the government works and what the Constitution is. And
let me take one more, Mark, let me take one more minute. I encourage people to look at the concluding statement that Senator Mitchell had when he was interviewing Ollie North in the Iran-Contra hearings. North started out being arrogant and pompous and cocky. And with the time George Mitchell from Maine got through with him, Mitchell had been a former federal judge, I was sitting behind Mitchell. North had gone from arrogance to sort of fear to, oh my God, I've been caught. I am so sorry. The visible change in his expression was priceless. If anybody wants, I dug that testimony out, send me an email and I'll send you a link to it because it captures some of the very things you're talking about just now, Mark. You can love your country and disagree with the policy, but you have to follow the law.
What a great message to conclude. Thank you. Thank you, Juliana, for hosting this. The Washington Foreign Law Society has been absolutely great to us in hosting these seminars. And pay attention to their agenda because all of the programs that are coming down the pipeline are quite robust.
Thank you, Mark. Thank you, Jeffrey. It has been really a pleasure to host you both for both occasions. I thank all the participants. Please come to our next event on March 30 and consider joining the society. Have a good evening.
Good night.
Thank you. Good night.
Bye.